what they are trying to do is to eliminate a needle in a haystack by destroying the haystack. Each shard of grain in that haystack is a human life.
Order, order. Welcome to today's special hearing on arms exports to Israel. If I may, Lord Sumption, just kick off with you. Could you just tell us why, in your view, having signed the letter from a number of lawyers, you believe that the UK government should now be suspending strategic export licences?
The Genocide Convention, which was the main line of argument in the letter that I signed, is important because it engages the responsibility of non-parties to the relevant conflict. It requires states who are party to the convention, including the UK, to, quote, prevent and punish genocide. And those have been held by the ICJ in previous cases as being completely distinct obligations, prevent and punish. And the prevent part of it is a preemptive position. In other words, it is directed to prospective as well as actual genocide, and it is also directed to suspected, plausibly suspected genocide, and not simply genocide that has been established as a fact. It's irrelevant, they said, that measures available to a signatory would not have been enough to prevent genocide. Essentially, one needs to do what one can, even if that is not a great deal. And that obligation, they said, comes into force whenever the signatory knows or should know that there is a serious risk of genocide, even if it has not yet happened and has not yet been proved. Now, the interim judgment of the ICJ on the 26th of January, and they found, first of all, that the Palestinians were a distinct group entitled to protection. Secondly, that the scale of loss and of life and damage to buildings, they made provisional findings about that based on the evidence given by the reports of UN agencies and the World Health Organization. They then went on to cite evidence of genocidal intent, consisting essentially of statements by the Israeli Defense Minister and the President of Israel, Mr. Herzog, some of which take one aback by the intensity of the hatred that they disclose for the people of Gaza.
I want to just ask with reference to the High Court judgment this week. The court documents also reveal that Israel is not providing the UK government with information on any specific incidents and continues simply to provide assurances after investigating itself. And in this context, can the government comply with the UK arms export regime?
I entered this fray with an interview on the Today programme, which I thought the time had come for the UK government to suspend arms export licences. It happened to be on the 3rd of April, and within about 3 hours, the letter from the 600 judges and jurists, the first of the letters, was published. And I had actually taken my cue from our own Foreign Secretary, and the increasingly forceful rhetoric that we had heard from the Foreign Secretary in the weeks leading up to that about the situation in Gaza. I was not positioning myself in a debate about whether genocide was occurring or not, but, for example, we in the House of Lords heard from the Foreign Secretary on the 3rd of March about the dreadful suffering in Gaza, the danger of this tipping into famine and danger of illness tipping into disease, and we are now at that point, people are dying of hunger. And then on the radio a few days later, the Foreign Secretary again said, it's incredibly frustrating that Israel was not taking the steps to allow more aid into Gaza amid a terrible humanitarian situation. He reminded us that Israel is the occupying power and that has responsibilities for the welfare and protection of the civilian population. Then we had the attack on the World Central Kitchen convoy, 7 aid workers killed. It was clearly a deliberate attack on those vehicles because they were badged very clearly. The fact that perhaps Israel had intelligence suggesting there were Hamas combatants, to use your phrase, in the vehicles was clearly wrong, and 7 humanitarian workers died. And that was not an isolated incident. So it was on that basis that I said, as a layman, I thought there was ample evidence at this point for the government to conclude that a suspension of our arms sales to Israel was justified.
Which there is a precedent in August 2014.
Which there is a precedent, and bearing in mind that we are not a major supplier of arms to Israel, my argument is open to the objection it would be a gesture. Another way of putting it would be that we take seriously our published conditions, criteria for supplying arms, which paragraph 2C of our criteria is that the government will judge whether there is a clear risk that the items might be used to commit or facilitate a serious violation of international humanitarian law.
The fact is that there has been a lack of discrimination in the Israeli response, which is profoundly troubling and particularly affects the operations of humanitarian agencies like World Kitchen.
If I may, Lord Ricketts, just return to the chronology in terms of advice, because I think yesterday in court it was revealed that the Secretary of State for Business and Trade last reviewed and approved arms sales to Israel on the 8th of April. But on the evidence from that hearing, the government hasn't reviewed whether Israel is committing IHL violations since the 29th of January in the context of export reviews. And it's not received any legal advice on whether Israel is complying with IHL on violations after the 29th of February. This would mean that the Secretary of State for Business hasn't considered any violations or atrocities from the last 3 months in their decision to keep exporting arms to Israel.
My advice to him would be to certainly keep the position under review and make sure you have the most up-to-date possible analysis on the basis of what's happening.
You'd accept the
including
point that three months ago is not up to date? Oh.
Yeah, I would be surprised if the last legal advice they had is 3 months ago, given the intense public controversy about the World Central Kitchen attack and everything that's happened since then.
I think the problem is that the methods used by the Israeli Defense Force are necessarily indiscriminate. Essentially, what they are trying to do is to eliminate a needle in a haystack by destroying the haystack. Each shard of grain in that haystack is a human life. So that I find it very difficult to see on the information available in the public domain how this can be regarded as a proportionate or a discriminate approach.
Israel has complete control over access to Gaza by land, sea and air, and therefore it is within Israel's control to facilitate or impede the import of humanitarian aid. The international community have been forced to the extremities of airdropping pallets of aid into Gaza, extremely dangerous process, by the way, since it can kill civilians, and even the US building a pier to allow aid to be delivered because Israel has refused to open Ashdod port or facilitate sea access to Gaza. Israel, as we know, took every step to undermine UNRWA, the UN agency, with a lot of allegations about UNRWA staff being members of Hamas, effectively blocked UNRWA operations in the north of Gaza. The World Central Kitchen withdrew after the attacks on its convoy. So the distribution of the aid that is piling up outside Gaza is itself extremely difficult. No doubt the situation within Gaza to distribute aid is very difficult. So, I think the evidence shows that Israel's allies have been increasingly frustrated that Israel has not been expediting aid at a point when there is famine, risk of famine in Gaza, risk of disease, lack of water and essential supplies and medical facilities.
Colonel Kemp, with your significant military experience, I'd really be grateful for your guidance, because we've heard about this issue of proportionality, and indeed the Prime Minister has said that there are too many people have been killed. I've reminded the panel of the 4 principles of IHL with which they're very familiar. But can I ask your opinion as a military operative, if I can, a renowned and decorated one at that, whether the killing of surgeons in hospitals by sniper bullet as they go about their duties, or the dropping of dumb bombs on residential dwellings in pursuit of a military target. Is that within the bounds of accessibility and proportionality?
I should just point out that I've been in Israel for most of the last 6 months, including spending time on the ground in Gaza on several occasions, observing the actions of the IDF. Israel is doing all that it possibly can to comply with international humanitarian law. The extent of British arms trade to Israel is extremely minor. It amounts to something like less than 0.9% of Israel's total arms imports. And most of that is, we provide no weapons to Israel. As I understand it, we provide only technical components to some systems that can be used for weapons or can be used for dual purposes.
But Lord Ricketts, Lockheed Martin is the lead contractor for the F-35, and that's built through an international coalition with 15% of the value of all 50 F-35s made in Britain. And Lockheed Martin themselves said the fingerprints of British ingenuity can be found on dozens of the aircraft's key components. Now, the intellectual property may have gone, but isn't there still that obligation upon the United Kingdom to, with reference to that significant contribution, to think about steps, even though it may not have a particular impact now, to demonstrate that commitment? It may be beyond a demonstration, but in concert with the moral obligations of this country.
If I understand your argument, you're saying that the UK should be prepared to take a review on how F-35s have performed, how they're used, after we've supplied components for them, after they've been delivered by Lockheed Martin to third countries. I mean, that gets us into pretty difficult territory, I think, because there will be British components in very many arms systems around the world, many made by the US. And I think the capacity of the UK to dictate how a weapon is used that has some components from the UK in it is quite limited, actually. So I'm not sure that that's going to take us very far.
Is there any obligation, perhaps Lord Sumption, upon us to acknowledging the contribution that we've made to the facilitation here, to take steps in response, and be that suspension of arms sales or something more nuanced short of such a suspension?
Well, legally, we have to do what we can. We are not required to do things that are likely to have no or negligible impact, but we are required to do what we reasonably can, and that includes assessing the effect that our decisions may have on other people who supply arms to Israel. The obligation legally is to do what we can. That undoubtedly leaves a margin of judgment to the UK as to what the best way of doing this is. But it's clear that they are obliged to do something. And arms sales have this special feature, which is not present in other kinds of sanctions, which is that they are concerned with material that is directly being applied in the military policies that at least arguably, and I think very probably, break international humanitarian law.